Please be seated. Good morning. We're here for oral argument in cause number 1CA UB18-0105, Johnson versus ADES. These proceedings are being audio and video recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is warned that it's your responsibility to watch the clock to reserve a portion of that time for rebuttal if you so desire. We have read the briefs. We've discussed this case in conference this morning. Counsel, you may proceed.
May it please the court, Justin Henderson, excuse me, on behalf of appellant Jesse Johnson. Jesse Johnson suffered a severe mental decline beginning at age 15, and his IQ has repeatedly been measured below 70. Just 2 years after he turned 18, his IQ was measured at 59. He's never recovered, and he's shown little improvement for over 20 years. He's been unable to take care of himself since age 15, and there's no dispute about any of this. The DDD has conceded that the tribunals below likely erred by applying the wrong standard. DDD agrees that an applicant for developmental disability benefits is not required to prove that he was diagnosed with a disability before age 18. The DDD's brief doesn't cite anything in the record that would raise an issue of fact. It's either confessed error or waived any argument that there are disputed facts.
Oh, but we could read the board's decision. And the board's decision focuses, as I view it, on cause. What was the cause of the cognitive impairment? And so I guess my question is going to be to both of you. Under the statute, does cause matter?
No, it does not. There is nothing in the statute that requires an applicant to prove the cause of the cognitive deficit. It's just not there. And yesterday, while I was preparing for this argument, I came across, and I'll file a notice of supplemental authority, some law review articles and some cases that state that in 30 to 50% of cases, nobody can prove what the cause of cognitive disability is. So if there's a cause requirement in the statute, and there isn't, that means that 30 to 50% of people with cognitive disabilities won't be eligible for benefits because they won't be able to prove what caused their disability. And that's why I think it's not there. It's not there in the statute anywhere.
I'm curious whether you're aware of any federal interplay here. In other words, if any of this is federally funded, if there are federal eligibility requirements or anything that may have affected the drafting of the statute, or perhaps even of the recently promulgated regulation that we should be aware of.
Not that I'm aware of. The only overlap that I'm aware of federally is in the death penalty context and cruel and unusual punishment. And the federal courts, this standard is it's recognized first in the medical literature, and then the courts have kind of just adopted it in various different contexts, including disability. You see it in Social Security benefits cases. So the standard's pretty similar. It's the same three factors. And I did cite some federal cases that said the issue really on appeal, I think, is whether the condition manifested itself before age 18, and I think the fair read of that, and I think the DDD has conceded of the agency's decision, is that it's based on a lack of an IQ test before 18. That was the only testimony that would lead to, and it was from the state's expert, that would lead to that conclusion. There's nothing else in the record.
But in other words, then, you're aware of no federal law, and I'm not talking about constitutional concerns here, but rather just funding laws that would relate to a need or lack of need to establish the cause of a disability or to examine the interplay between the disability and a mental illness.
So I'm not aware of anything on the federal level or anything that went into the drafting of the statute. There is one statute, the only statute that discusses cause really, I think, at all, is Section 36-551-6, and it just says there has to be a causal relationship between the presence of an impairing condition and the developmental disability. It seems a little circular to me because there's at least some overlap, but I think that all that requires you to prove is that you have the condition and it's causing you to have trouble living your life.
What does the condition mean?
The condition is sub-average intellectual functioning, and so that's measured by the IQ test.
Okay,
and
but a
then
condition could, I suppose, also include a mental illness.
I believe so, yes. The statute, I think the cognitive disability portion of the statute is kind of like a catch-all. It just says if you have sub-average intellectual functioning and you have more than 3 functions of your daily life that are significantly affected by it, that's it. And I think a mental illness could qualify. A mental illness could cause you to have sub-average intellectual functioning, and that could cause you problems in your life.
But there are regulations in the Department regulations that do impose a causal relationship that would exclude mental illness, correct?
I don't know.
I can give you the site if you want to.
Sure. I believe you. But
6303. It's enacted after this proceeding.
I haven't seen that. I didn't see it cited anywhere.
It wasn't.
And so that's why I'm not aware of it. I would submit that it's contrary to the statute. I don't think that the department can impose additional requirements that aren't in statute. In the Cook case, it was a policy there, but I think the idea is the same. I see this as identical to Cook because if you take a look at the transcript, what the testimony was, well, there was no IQ test before age 18, and the department policy means that you don't qualify for benefits. The only other testimony was something about, and I couldn't really understand it, if you have, I think, like a comorbidity type of situation where you've got mental illness and a developmental disability, and they're kind of together, the witness said you have to establish the disability before the mental illness. That's also, I think, in a policy, which I haven't seen. I took a look at the policy yesterday.
Make sure I understand what you're saying, though. If you establish the disability, then would your position be that we just don't care about the mental illness at that point because eligibility has been established?
Yes. Okay. I think mental illness could establish a disability. I think you could establish a disability otherwise. It could be genetic. It could be a car crash. You hit your head. It could be anything. And I think the statutory language is broad enough that it encompasses really anything, as long as you're able to prove a low IQ and that it has a significant effect on 3 things in your daily life.
Well, and that was the basis. This is going to sound like a statement, but it's really a question. That was the basis for the medical doctor's testimony from the department on her belief that the cause was the schizophrenia.
Right.
But I take it your position is we don't care if it was schizophrenia or something else, the mold or whatever. The statute just says you have to have that cognitive impairment.
That's right. Yes. And I think even if we were supposed to provide some kind of cause, the testimony in the record shows toxic mold exposure. And Jesse's physician testified that caused the disability, along with some other things. That's unrebutted. There's nothing in the record that rebuts that. So well,
her testimony was she didn't believe it. She thought it was schizophrenia. So I mean, if cause is an issue and mental illness can be excluded as cause, then her testimony, I think, would make it a factual determination for remand, wouldn't it?
I don't think so, because like I said, I don't think it matters if it's schizophrenia or something else. It just doesn't matter. All that matters is that Jesse's been impaired since he was 15. He always has been. He always will be. And we have IQ tests that prove that it is related to a cognitive disability. So I don't think there is a factual issue for remand. I think, like I said, I think the Cook case is the one that's most on point, because if you look at the state's expert witness, she's basically doing exactly the same thing that the state did in Cook. And I think it would be an abuse of discretion on this record for the agency to conclude that there is no entitlement to benefits. And this court has remand would only be appropriate to direct the department to award benefits. And this court has done that several times in the Cook case, and a couple of other cases that we cited in our brief. The issue really on appeal, in a lot of this stuff also, the only issue on appeal is whether it manifested before age 18. The state didn't cross appeal. That's the only issue that we appealed on, because it's the only issue that the agency said we didn't meet. It said we fit all of the other criteria. And so that's the only issue really before the court also. I think the other issues, the state wants to basically get a complete do-over. They're asking for a revisiting of all of the elements of a cause of action for these benefits, even though the appeals board said, you clearly have significant limitations. You clearly have, your IQ has been tested below 70 always, clearly causing you problems. And so if there is a remand, it should be first just to award benefits. But it also should only be limited to the issue that we appealed on, which is whether it manifested before age 18. And I don't think there is no factual dispute about whether it manifested before age 18. So I'd like to...
Can I ask you some questions about
course.
attorney's fees?
Yes.
Assuming we agree with you that a remand is appropriate, are DDD members entitled to benefits? Are those monetary benefits, or its equivalent for assessing whether or not we should award attorney's fees?
I do not think that they are monetary benefits or the equivalent. I'm only aware of 2 cases addressing the exception in subsection 8, or subsection H, I'm sorry. And the Supreme Court, and both of them say the exception doesn't apply. In Supreme Court's case, Tortaro Waters Users Association versus Steiner, which is 148 Arizona 314, the court said it applies to things like welfare payments or a disability pension payment. So it's cash payments. We're not asking for cash payments. We're asking for services, more along the lines of medical services or something like that, not cash from the state. So I don't think that exception applies. In Cortaro, the Supreme Court said it doesn't apply simply because a party might obtain some kind of economic benefit, because you're almost always going to be able to identify some kind of economic benefit. But I don't think we're asking for an economic benefit here. We're asking for services.
And in that same vein, would the award that we, assuming we made such an award, would it include the expert witness fees that were incurred at the board hearing, or should we just simply defer to the board to make that determination?
I think this court could do it on an application. If you look at subsection I, it includes fees and expenses, the reasonable expenses of expert witnesses, things like that, all fees and other expenses that are incurred in the contested proceedings in which the decision was rendered. So I think it's everything. Agency level, this court, and this court, I think, could do that on a fee app.
It just seems odd, because it's not typically what we normally
right.
do.
And you could do it on remand. I think it could do it either way.
Meaning we could tell the board to award fees?
To award fees.
But they don't do it either. That's the odd thing.
Yeah.
because the statute is only implicated on review of the board's decision.
Right, and that's why it seems to point to this court doing it.
Yeah.
Is precisely for that reason, because it talks about winning in this court, and then it says these are the fees you get if you win in this court.
Okay.
So that's why it's a little awkward. I understand normally you would remand and have the trial court consider a fee application, but the statute seems to suggest it. And I think it's hard to tell from the court opinions, but in Cook, it seems like this court awarded the fees. It's hard to tell for sure, but.
Well, it just seems odd that we would be making a reasonable determination on something that didn't happen in front of us. It
is unusual. I agree. But on the other hand, reasonableness is kind of an objective standard, and I think that any judge should be able to look at a fee application to determine whether it's reasonable or not. And the state could certainly point out things that they don't think are reasonable, and I think it could be done just by way of motion. If the court doesn't have any questions, I'd reserve the rest of my time.
All right, thank you, counsel.
Thank you.
Good morning. May it please the court. My name is Joanne Falgett, and I'm representing the Arizona Department of Economic Security in this matter. I'd like to start with talking about the requirement of cause that Judge McMurdy had asked about. The statute does require a cause, and it does require a specific diagnosis. There are 4 listed diagnoses in the statute which will qualify one for benefits under the DDD statutes. And those are cognitive disability, cerebral palsy, epilepsy, or autism. Each of those is a diagnosis in the DSM-5. There's a difference.
But is there anything in the statute that refers us to the DSM-5?
The statute doesn't specifically cite the DSM-5.
And the cognitive disability is actually defined
It is
by
defined.
statute.
That's correct.
And nowhere in that definition does it reference the cause.
So, 2 things there. It does say it means a condition that involves sub-average general intellectual functioning that exists concurrently with deficits in adaptive behavior. That's the definition of it. But also, ARS section 36-551-6, also in the definition section, says, okay, well, let me back up a little bit. 36-551-19 says that a developmental disability is a severe chronic disability that is attributable to cognitive disability, cerebral palsy, epilepsy, or autism. And then the attributable to is defined in 36-551-6. Attributable to cognitive disability, epilepsy, cerebral palsy, or autism means that there is a causal relationship between the presence of an impairment. I mean, that's what it talks about.
So repeat that again?
So-
Is attributable means what?
Let me get out the actual
Actually,
words of the
someone just
statute.
handed me the statute. Right?
Actual statute here just a second ago.
It sits right here.
Yeah. Between. Well, what is the impairing condition
So,
under?
okay, so
cognitive
to back up again, there are 4 different conditions which will make one eligible for services. One of them is the cognitive disability. Now, there's a difference between a cognitive impairment and a cognitive disability. Cognitive disability is the defined term. It's the condition that will allow a person to become eligible for DDD benefits under the statute. A cognitive impairment can result from a number of different things. A cognitive impairment can result from, as Dr. Tom testified, schizophrenia. Okay, but schizophrenia is its own separate diagnosable condition that
Where
does
do we
not,
see the use of cognitive impairment in the statute?
it's not used in the statute.
Then
and
why
that's
are we talking about it?
because I think that those concepts have been conflated in the briefing. In other words, they're arguing that because he has these cognitive difficulties, it must be a cognitive disability, and therefore he qualifies under the statute. But what I'm saying is there's a distinction between having cognitive difficulties that may result from some other diagnosis, such as schizophrenia.
Where is that distinction found in law, though?
These are diagnoses under the DSM-5. It's found in the psychological literature.
It always worries me when courts and lawyers talk about the DSM-5, because I'm not aware that the DSM-5 certainly is in any way legally binding, and I question, even its own drafters question, whether it's admissible. So why are we talking about the DSM-5 when what we have before us is an act of the Arizona legislature?
Right, and it appears that the Arizona legislature picked out 4 very specific types of disabilities that will allow a person to become eligible under these statutes.
And defined them.
And defined them, that is correct.
And the definition of cognitive disability in 14 gives a very specific definition, and it does not, it could have referenced psychiatric standards or psychological standards as pursuant to the DSM, but it didn't. It gave us a very specific definition that the board's finding meet every criteria that I can see under that definition.
Okay, well, one thing that, for example, under Arizona Administrative Code R6-6-302, which was effective up until 2018, was effective at the time that this was happening, and the rules have been amended, so you have to be kind of careful.
You're talking about the prior version.
The prior version that was in effect at the time that this was all happening. Subsection A, R6-6-302, A defines who may determine if a person has the statutory conditions for mental retardation, cognitive disability. It has to be determined, quote, by a qualified person who performs psychological evaluations using tests that are culturally appropriate and valid. So if we're requiring a qualified person who performs psychological evaluations using these tests that are culturally appropriate and valid to determine if a person has one of those statutory conditions, that indicates that what we're looking at is a determination based on medical or psychological or psychiatric personnel that the person suffers from an actual diagnosable psychiatric or psychological condition, or in the case of epilepsy, a medical condition. So the legislature has set forth these very specific defined conditions for which DDD benefits are available. Now, as
Given the legislature's specificity, though, shouldn't we take that to mean that criteria the legislature hasn't identified shouldn't be included in our analysis?
Well, yes, and so that is why we agree that the requirement that the department head said that they had to have measured the intelligence before the age of 18 is inappropriate.
But why wouldn't that same concession then apply to the issue of causation?
But it does say that the resulting life or substantial limitations of life functions has to be attributable to one of these four disabilities.
Right.
Defined
And
disabilities.
there's no dispute, as I read it in the record, about that being satisfied here.
But about which one being satisfied, I'm not sure I
The
understand.
cognitive disability.
There is a dispute in the record about the cognitive disability
What?
being
Okay, now
satisfied.
we've come full circle. What's the dispute about the cognitive disability?
Because if you have cognitive impairment that is caused by something else such as schizophrenia, you may have some cognitive deficiencies, but it's because of the schizophrenia. What they're looking at for a cognitive disability is a more organic, it's a defined disability, this cognitive disability, that doesn't result from, for example, schizophrenia or...
I've got the definition here one more time. It means a condition that involves sub-average general intellectual functioning that exists concurrently with deficits in adaptive behavior manifested before the age of 18 and that is sometimes referred to as an intellectual disability. Nowhere does it say excluding schizophrenia or any other mental illness. It could have, but it doesn't.
Because the generally accepted terms cognitive disability and intellectual disability, as used by people who diagnose these kinds of conditions, are separate and distinct from things like schizophrenia.
So they
or
could have
other
said
disorders.
cognitive disability as generally accepted in the community, but it doesn't. It actually defined it for us.
Right, and it defined it as the sub-average general intellectual functioning that
Okay,
is
let's stop
sometimes
there.
referred to.
Did
But-
he have sub-average general intellectual functioning?
Yes.
Okay. That exists concurrently with deficits in adaptive behavior. Did he have deficits concurrently with adaptive behavior?
I believe so.
Okay, because the
Certainly
board
there's-
found that. And it happened before the age of 18.
Well, that's disputed, certainly. There's some dispute about that in the record, but
I was
That it
unaware
happened
of-
before-
my main beef
Well,
with it.
let's finish.
Okay.
And it happened before 18.
We don't know whether any cognitive disability happened before the age of 18.
Is there any evidence that it happened only after the age of 18?
I don't know that there's a cognitive disability at all, but if there is, yes, there's evidence that it may not have been because of things that happened before he was 18.
Well, the board says, and I'll read it for you, it says, there is ample evidence that the claimant began to display significant changes in his behavior, personality, and general functioning at age 15.
Correct. General changes in his behavior and functioning, but we don't know whether he had a cognitive disability before the age of 18. The part that really gets it is and that is sometimes referred to as intellectual disability, which again, we're talking a disability, not merely an impairment resulting from some other condition.
What do we do with the definition that says, and that is sometimes referred to? How can a court work with that? Things are sometimes referred to as other things all the time.
Right, and I understand that the definition is maybe not the most artfully drafted, but I submit that in its context with other diagnosed conditions such as autism and epilepsy and cerebral palsy, that cognitive disability has the usual meaning that it has among people who do diagnoses. You're not going to go to a psychologist or a psychiatrist and ask them to diagnose you and have them decide that you have schizophrenia, and they're just going to call it cognitive disability. They're going to call it schizophrenia. Or
they may very well say that as a result of the schizophrenia, there is a cognitive disability.
I guess I can't say I'm not a psychologist or a psychiatrist, but the way that I've most often seen that stuff written is schizophrenia and a resulting cognitive impairment, which is a different thing. It's because the schizophrenia is what's causing all of the problems. Dr. Tom testified that it can result in substantial...
Are you basing all these distinctions on the DSM-5?
I don't know about the DSM-5, and that's probably why they defined it in the statute, because they recognize that the DSM standards
Yeah, when
changed.
DSM-6 comes out, are we going to change the law automatically?
But again, because it's requiring a diagnosable type condition, it's a separate condition that would be diagnosed, not just an impairment that results from some other diagnosis. There's a lot of testimony in the record as well from Dr. Tom, and I can't remember which other one, Dr. Gray, I believe it was, that schizophrenia, for example, if properly treated, some of those cognitive issues can go away. So that wouldn't be a cognitive disability. A cognitive disability is going to be sort of a standalone thing that on its own is going to cause substantial impairment throughout the course of the person's life. Similarly with the mold, actually, Dr. Gray testified that with the mold exposure, if if Jesse Johnson would simply follow the regimen and clean out his system, he would get rid of those toxins and substantially be restored to his prior condition.
I believe the doctor even testified that mold just doesn't cause mental impairment.
That's correct. So, and again,
which is rather absurd on its face, right? I mean, there's no evidence to support a statement of never or always.
Yeah, I think what Dr. Tom actually said was that she had looked and done a bunch of research and had not found any evidence that the types of stuff that Dr. Gray was talking about would cause any illness in people. So,
but does the agency contend that the version of R66303, which was enacted last year, applies to this case?
I would think that the rule itself wouldn't apply because it wasn't in existence at the time all these proceedings were going on. But I do think it does reflect sort of the general understanding of how these statutes work.
Can the rule apply to Mr. Johnson ever over the course of his lifetime when he seeks services from DDD?
That's an interesting hypothetical question. So the statute does provide that if, for example, the person is given services and they're cognitively disabled, or they have epilepsy, or they have autism, or whatever they have, and they are given services, and they actually improve to the point where they are no longer functioning at that 2 standard deviations below the mean, which qualifies you for the substantial functional limitations, then their services can be terminated unless they can demonstrate that they need the ongoing services in order not to backslide. On the other hand, then they can reapply later.
But my question is, does the agency take the position that at some point in the future, assuming Mr. Johnson is awarded services or granted services, those services may be rescinded if due to this onset of a mental illness issue under the reg?
Okay, so I'm not sure how to answer that. If it is found that he qualifies, has a cognitive disability and qualifies, then the question is really about the standard deviations and the functional limitations. If he improves to the point where he is no longer considered to be have those substantial limitations, then the services could be terminated. If he were then to reapply, the claimant always has the burden of proof to prove that they're eligible for the services, and I would assume that the regulations then in effect would apply.
So what I hear you saying, though, as long as he continues to manifest the life limitations, there would not be a revisiting of the issue of eligibility based on the onset of a mental illness.
The eligibility can be determined, well, the director does have the right to review it at any time, but based on that, whether they still qualify. But as far as the automatic, they get reviewed at age 6 if they'd had services under the age of 6, and again at 18 to determine whether those services should be terminated. They have to apply to continue services past the age of 18. But yeah, I mean, the director or the department can review and make sure that the person is still eligible, but they're not going to, if they've had their qualifying diagnosis that's been found, then I don't think that they would just change that. I suppose if the legislature amended the statute and removed one of the foundations, they might, I don't know. But that's all hypothetical because that's not really what's happening here. What we have here is a situation where there were some disputed facts, as you've noted in the board's decision. And the problem that I see is that the board considered a completely inappropriate fact that he had not had his intelligence measured before the age of 18. So it is appropriate then to remand the case to the court. So under Mercy Healthcare versus Arizona Healthcare Cost Containment System, if the trial court applies the wrong test to the facts, then if reasonable inferences about material facts could be resolved in favor of either party, the case must be reversed and remanded for a trial on the merits, and that's page 98.
Oh, I'm sorry,
So,
Peter, I interrupted you.
Those reasonable inferences would have to be material under the statute.
right, and
What inferences do you think could reasonably go either way that are material?
so again, if he has schizophrenia, for example, is what is causing the issues, then that would be a non-qualifying condition. On the other hand, if the board were to, because what the board found also,
Yeah,
you had.
but that requires us to first determine that we agree with your assessment that you have to determine the cause to, under the statute for a cognitive disability.
That cause is
Also,
relevant.
there were a number of facts, a number of things that happened. They had, his father had died, he had bicycle accidents, he had car accidents, he had allegedly an initial mold exposure when he was 15 or so, later mold exposure from the time when they moved into that other house that happened potentially after he turned 18. And it's unclear when exactly if there is a cognitive disability.
All that stuff is interesting from a treatment and social perspective. I cannot find anywhere in Arizona law that any of those facts are relevant.
Well, again, it does go to when the condition manifested, and again, whether there's a cognitive disability. I just real quickly wanted to address the fees issue under 12348H1. Our position obviously is that they're not entitled to any kind of attorney fees because they are precluded under that statute. Clearly, any kind of services, and the department provides services that it has to pay for. It refers to services such as medical and nursing, in-home care services. All those things have to be paid for out of money. So I submit that applying for these DDD benefits opens up a whole host of services which the person would otherwise have to pay for, and that is, in fact, money or its equivalent.
What's your
And
best
so-
case for that proposition?
So-
Services are the monetary equivalent.
There are very few cases on this issue at all, and I don't have any Arizona cases at all that say anything like that. The Cook case that was decided, That one just simply said we're awarding fees with no analysis, no discussion of H1, and so I submit that that case is not even precedent for the idea that H1 does not apply. The Cortaro case actually is pretty good authority because it talks about that you can't award fees if it's not a monetary benefit or its equivalent. But that was an administrative proceeding regarding water rights. And so that was something where the person would have some right and may or may not make money out of it. But here we have the state that's actually going to be paying for the case management services, paying for the medical services or the in-home nursing services or whatever else. That is a monetary equivalent that is paid directly out of the state's pocket. It's not just about whether the claimant can go and make money or not based on some right that they're given. I see that I'm out of time. Thank you for your time this morning.
All right, thank you, counsel. Any additional words?
I think that, Judge McMurray, the way you kind of walked through that definition, it was useful because that's really the only one that matters, I think, is the cognitive disability. And I don't think there is any factual dispute about any of the things that are listed there. Even Dr. Tom testified that, and this is a quote, that he had symptoms that manifested themselves prior to age 18 that reflected a sharp drop in cognitive functioning. It's their own witness. So I don't think there's any factual dispute here. And just to touch on one issue, to get back to the causation issue, if you look at 551 subsection 6, where it talks about attributable to cognitive disability, epilepsy, cerebral palsy, or autism, I don't think that would require somebody who had autism to show what caused their autism. So why is I think that just highlights there's no requirement that we prove what caused the cognitive disability. It's not there. So with those two comments, unless the court has any further questions.
Thank you very much for your argument here today. The case will be deemed submitted. We'll issue a decision in due course.